Hello friends, in the series on the income tax cases, today we will discuss a very important issue on the limitation period of passing the penalty orders. The limitation period for passing the penalty orders is very concisely given in section 275 subsection 1 clause C. It has been seen that the department is misusing the limitation period given in the section 275 subsection 1 clause C according to its whims and wishes, and try to extend the limitation period by issuing the notice under section 274 and then calculating the period of 6 months from there. So what is the exact period of limitation has been taken up by Honorable Delhi High Court in the case of Principal Commissioner of Income Tax versus Thapar Homes Ltd, and this case is reported in 483 ITR at page number 248, and the date of the judgment is 11th September 2023. The assessment order for the assessment year 2008-9 has been passed on 31st December 2010. If we analyze the limitation period under section 275 subsection 1 clause C, then there are two limbs of that section. The first limb says that the penalty is to be imposed on the assessee within the financial year in which the assessment order has been passed. Meaning thereby that if in the present case, if we take the example, then the assessment order is passed on 31st December 2010. So according to the first limb, the limitation period expires at the end of the financial year. That is in the present case, that is 31st March 2011. Now, if we come to the second limb of section 275 subsection 1 clause C, that says that the penalty is to be imposed on the assessee within 6 months from the end of the month in which the penalty is initiated against the assessee. In the present case, the revenue has issued the penalty notice under section 274 on 13th June 2011. The assessee challenged this penalty notice as time barred. The revenue was pleading that the penalty order can be passed within 6 months from the end of the month in which the penalty notice is issued, and the revenue was contending that since the penalty notice has been issued on 13th June 2011, so now they can impose the penalty within 6 months from the end of the month of June 2011. But the assessee pleaded that the decision to initiate the penalty was taken in the assessment order passed on 31st December 2010, because it has been seen that the department decides to initiate the penalty against the assessee in the assessment order itself. And in the present case, the assessment order was even passed with the approval of the approving authority. So it was the viewpoint of the Honorable Delhi High Court in the present case that precisely the department has consciously taken a decision to initiate the penalty against the assessee in the month of December 2010. So the 6 months were ending on from, if we calculate the 6 months from December 2010, then the 6 months will be completing on 30th June 2010. But in the present case, the penalty notice has been issued under section 274 on 13th June 2011. So the notice is time barred, and hence the penalty proceedings are time barred. The court said that the revenue cannot decide the limitation on whims and wishes, and once the revenue decides to initiate the penalty, then it is the duty of the revenue to keep an eye on the limitation period. Friends, this case is very important because Section 275 subsection 1 clause C, when it is read, it seems that there is some confusion, but the Honorable Delhi High Court has cleared the cloud from this section, and this case is very important as far as calculating the period of limitation under Section 275 subsection 1 clause C. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Thapar Homes Ltd, and this case is reported in 483 ITR at page number 248, and the date of the judgment is 11 September 2023. Thank you, friends.